All right. So indemnification is a clause whereby we'll say you, the designer, would be agreeing that you're going to indemnify, which would be to make whole your client for any damages that client sustains as a result of your services. That's the very broad picture. Now, there are a lot of things wrong about what I just said, but that's the way many of the contracts are being written today, is to say that you are going to be responsible for any damages and losses that your client incurs as a result of your services, and that you're going to indemnify them and hold them harmless for those damages and losses and expenses and attorney's fees, etc. Now, notice I didn't include the word defend. So you'll often see in these clauses it says you'll indemnify, hold harmless, and defend. So as a first point, we want to delete that word defend. We as professionals should not be defending our clients. That is uninsurable. There's an issue in your professional policy that there is an exclusion for contractual liability. So there are two key exclusions: the express warranty exclusion and the contractual liability exclusion. So if by contract you agree to take on a warranty, then the policy says, sorry, that's nice that you have this warranty. We're not covering you for that warranty. We're only covering you for breach of standard of care. If you agree to indemnify your client for anything other than damages caused by your negligence, again, that's not insurable under your policy. There's a specific exclusion called the contractual liability exclusion that says no coverage. So we don't want to fall into that trap.
That's so important, Ken. If I can interrupt you real quick.
Yeah, absolutely.
Because a contractor who has a general liability policy is able to pick up that contractual liability, right? It is included in that, and you can have a whole big long conversation about whether that's right, and the comparison between the general liability policy of a contractor versus a PL of a design professional. But I think that's such an important point to hammer home, because sometimes the reason those are written in there is because this is the wrong type of contract, right? We're signing or we're taking a look at a contract that should not be between an owner and a design professional. It's between an owner and a GC. And out here in California, we've got Civil Code 2782.8 and Senate Bill 496, which was passed in, is it going on 3 years ago now? That duty to defend is just, it can dominate conversations. If there's one thing about contract review that I have that conversation over and over again, it is that defend, right? That one little word.
Right. Yeah. And so in California, Zach, I know that, we review a lot of contracts in California. And I'm not a California attorney, but I often have California attorneys arguing with me, oh, you don't need to delete that word defend in the contract, because in California, you can only be required as a design professional to pay the attorney's fees to the extent of your liability. So that protects you. And I'm like, yeah, not good enough. I'm not happy with that. I still want to delete the word defend, because to me, as soon as I agree to defend, you can't defend somebody after the fact. The only way I can defend you is that means I'm standing up right now and fighting your fight for you. If you hired me to be your defense counsel and I said, oh, okay, good. After you lose your case, I'll come in and pay your defense costs. That's not what defense is.
Right. So
when people loosely use that word, and even in California, say, well, the duty to defend only applies to the extent of negligence. That's nonsense. So I delete the word out. And in addition, in California, because the statutes and the courts interpret the law to say that if you agree to indemnify and hold harmless your client, that automatically picks up a duty to defend, just automatically. But the courts go on to say, but you can delete that duty. You can affirmatively say you don't have it. So I always say a little parenthetical. We agree to indemnify and hold harmless, but not defend. And then we go on. But we always need to affirmatively say we are not going to defend.
Awesome.
So
can you just define for us really quick what hold harmless means? It's a word that we see in contracts all the time, and I think there's kind of some misunderstanding or misnomers about that.
So great question, and no, I can't. But I'll give you some thoughts.
Sure.
But I think hold harmless is a term that actually is not understood universally around the country. You could ask attorneys elsewhere and people would probably come up with different meanings for it. So to me, hold harmless is, one thing is that I myself am not going to go after you for damages. So I'm going to waive anything I might have against you in the right of recovering for damages you might have caused to me. I'll hold you harmless for those. Hold harmless. Some people have said, well, actually, that sounds like a duty to defend. I'm going to indemnify you. Indemnity is after the fact. After you've incurred your losses, I'm going to make you whole after the fact. After you've been determined liable because of me, I'm going to indemnify you and pay you for those costs. Hold harmless must be something different, but it's not quite clear in exactly what it is. But some people would say, well, it might kind of suggest a defense aspect, but I don't think it does. The words protect get much closer to a duty to defend. So sometimes you'll see, I will hold harmless, indemnify, and protect. Mm-hmm. If I see protect, I'm like, well, wait, what could protect mean other than defend you? So I strike out those words because I'm like, that sounds a little too close to defense. So, but I don't worry about hold harmless. I mean, it's been so universally used that most people would say, oh, they're synonymous, indemnity and hold harmless. I'm not convinced they are, but it's generally, they just go hand in glove.
Right. No, that was great because I've heard that over and over again, and I've struggled with that myself. And there is no kind of universal, answer to that question. So, Okay. Great.
All right. Now, just a couple points on indemnity. For one thing, it used to be if you looked at a contract from 30 years ago and there was an indemnity clause in there, it would say something like, you will indemnify your client for bodily injury and property damage claims. That was a typical general liability indemnity clause. And often that would also be the professional liability clause. You're going to indemnify them for bodily injury, property damage claims. Well, then it kind of changed and it says you're going to indemnify them for all damages and losses, including but not limited to property damage, bodily injury. Now, it generally doesn't even mention bodily injury, property damage. It just says you're going to indemnify for all damages, losses, expenses, blah, blah, blah. Well, wait a minute. What they've effectively done is they've opened up this huge door to say that if they've suffered a damage, even if there was no third-party claim against them, and you have to understand a BIPD claim was a third-party claim against your client. And then they're recovering from you for those losses they had to pay to that third party. But now they've gotten rid of all that, and they're just saying you're going to indemnify them for all damages and losses they have because of your service. Well, that could include their first-party damages, even though they didn't get sued. They just simply lost money on the project. And what we've seen in the last few years is all kinds of clients suing design firms for their first-party losses and using the indemnity clause. Now, the problem with that is that they can withhold funding from you. They can use a withholding clause in the contract to grab money from you, saying, well, you're going to owe us indemnity, so I'm just not paying you the last $1 million under your contract. And they never have to prove damages. I mean, they never have to prove through an expert witness that you've missed a standard of care because they're holding the money. They just simply grabbed it under the indemnity clause. And a lot of these indemnity clauses are not negligence-based. And we're going to talk about that in a minute. So they have the indemnity clause so broad that they can recover their first-party loss for damages caused by you. And they'll say things like from your acts, omissions, errors, and negligence or negligence. So you've just, through the indemnity clause, expanded your standard of care to perfection once again. Mm-hmm. So, be careful of that. This slide, I'm just focusing on that whole idea of they should not cover first-party claims. And you'll see I have a sample I'm going to share where I say it's only going to be third-party claims. And then be careful about wording. Read it carefully to make sure you're not agreeing to indemnity for all errors and omissions, even those that are not negligent. And all damages so long as a little tiny bit responsible, meaning they'll say, well, damage is caused in whole or in part. It was a little bit in part by me, but now I've agreed to indemnify you for the 100% of damages that you incurred because I was at least one little tiny scintilla responsible. And that's the way courts interpret that language, in whole or in part. It doesn't say to the extent caused. It just says I'm responsible for all damages as long as I was just a little bit negligent or just a little bit responsible. So the next slide, I deal with that in whole or in part wording.
Right.
Okay. We want to get rid of that. Whenever we see that wording, it's really important to get rid of that. And the way I like to get rid of it is I like to say that we're going to indemnify for damages arising out of third-party claims. And then I say to the extent caused by our negligence. So instead of in whole or in part, we're saying, no, only to the extent caused by our negligence. Now, as long as we have that wording to the extent caused by our negligence, then it's okay to add, and a lot of clauses contracts do, they'll say, well, even if caused in part by the client. Well, that's okay, because we've only agreed to indemnify to the extent caused by us, right, even if some damages were caused in part by the client. Well, that's just a so what? We understand what we mean now. The client may not have understood that they're not getting what they thought they did, but the courts do. As long as we say we're only indemnifying to the extent caused by our negligence, that's all the court's going to make us do.